Hello and good morning, everybody. Welcome to another Hangouts and Headlines. We've got a meaty one for you all today, so we're probably going to get into the substance of it a little bit earlier than we usually do. But before we do that, where's everybody chatting in from today? How's the weather? How are you feeling? It is August 2025 already. It seems like the summer has gone so fast as it is, but I'm excited about talking through artificial intelligence with you all. So let me know. I will catch you in the chat. I will pull it up on screen and we can go from there. James Randolph says he's from Michigan. Fantastic. I think as many of you know, so am I. So good to have you here, James. Thank you for being both in chat and in my home state. I hope you're having a good one already. I know it's early days. All right, what else we got here? Lucy, good morning, Hoeg. Good morning to you, Lucy. I hope you're ready for some fun legal talk as well as some fun media talk here in Hangouts and Headlines. We've got both today. A little bit of a Hangouts and virtual legality crossover. It's going to be a fun one. It's going to be a meaty one. I've got 2 different lawsuits to go over with you today as part of this article read through. So get excited. Nick says, I love this subject. I love talking about this subject. I certainly love thinking about this subject, artificial intelligence, as a longtime fan of science fiction and fantasy. We are living in a very strange, almost science fiction world. And honestly, the legal system isn't equipped to deal with it. I'm not sure us as humanity are equipped to deal with it. And that's part of the fun of this conversation. So thank you for being here, Nick. Very happy to have you. Nakalad, morning, checking in from New Zealand with a beautiful mountain as your profile picture. I think of course, like many do, the Lord of the Rings when I think of New Zealand. And I think of those mountains when I think of the Lord of the Rings. So I hope you're having a good one. Thank you for being here. Very excited to have so many of you here already. 5 minutes into the show. 30 viewers. Keep it up, folks. Let's have some fun today. Against the Tide, our wonderful mod is already in there talking about things, as well as, I think, where she's chatting in from, Utah. I hope things are great in Utah, Tide. And thank you so much for being here and doing all that you do for the channel. I couldn't do it without you. I say that a lot about a lot of things here, but I really couldn't do it without Tide, our wonderful mod, who is always putting forth reminders that these streams are happening on Twitter or X, if you prefer Elon Musk's naming convention for that platform. I really appreciate all of their work, and I hope Utah is lovely already this early in the morning. Sibling Creature says it's been too long since I caught a live. Yeah, I don't think I've seen your name in the chat in a little while, Sibling. I'm glad to have you here today. We're going to have a wonderful conversation. I think we're going to have a wonderful, meaty stream of interesting topics to talk about, so thank you for being here. James says science fiction made AI sound better when it wasn't killing us. Laughing out loud, crying emoji. Well, I think science fiction often suggested that the AI would kill us, right? The most famous of which being Skynet and the Terminator franchise, with the robots sent from the future to kill us as a result of an artificial intelligence that has decided that humanity was just too much for this planet Earth. Hopefully the AIs are not going to generate into Skynet. I'm not sure we have the proper protections to prevent that if they wanted to. And that's certainly part of the existential dread that I kind of feel is going around society right now. But outside of existential dread, we've also got commercial dread, which is what Universal Pictures is dealing with, which is what we're going to talk about as part of our article today. James also says Tide is the best mod. Tide is awesome and is always asking me about moderating decisions and always in my direct messages asking me questions about how to better help you all in the community. Honestly, I could not be happier with how this community operates right now, asking interesting questions, dealing very, very well with controversial and sensitive topics that I have kind of eased into a little bit more as I've come back to making videos more often. And I was worried, I have to be honest with you all, about how that would be received by some folks in my own community because the internet is so often a hellscape. And you guys have proven more than up to the task. And so we can talk about not just video games, not just pop culture, but also things of significant importance, like how the law is dealing with artificial intelligence, which I know is an area of some drama online as it stands right now. Nick has some examples for artificial intelligence-based questions. For example, how many authors have not been inspired by older works? Did Robert Jordan ask permission of J.R.R. Tolkien before he started writing his first book in the Wheel of Time series, etc.? We're going to talk about authors. We're going to talk about books. We're going to talk about creative writing. It's all baked into this conversation. So yes, I will talk about why this video is so big when we get to the substance of it. But yes, this is one of those questions that is going to come up as part of the analysis of what artificial intelligence companies can and can't do. Tide said, I was careful with the pick I used today. At first, I was going to make you a dinosaur trainer with a real-looking dinosaur, but decided against it with reading the title of this stream, Hoeg. Yeah, dealing in artificial intelligence-created imagery like you do, I can understand why you might be a little bit more conservative about the pictures that you use for this particular stream. As we will see, what is and isn't allowed in the artificial intelligence side of things is much more complicated than really anybody is saying online, certainly, but even the plaintiffs and the defendants in these cases. So it is a very complicated area of law. We're going to talk through it as best we can on a YouTube video, on a live stream with you all today, as part of discussing what Universal Pictures is trying to do. So, sibling. I mean, the way it's being pushed into everything and anything these days, it's that not setting things up for a Skynet scenario. I don't know what is. Well, I do think that Skynet didn't have, when it was created as a creative possibility for the Terminator franchise in the 80s, the notion of the kind of tech bro push for rapid development of technologies with a break it and then figure out what it does kind of mentality. So I do think that that's a setup for maybe not having the proper guardrails around some of the stuff we would want to see guardrails around. And that could lead to problematic circumstances in a Skynet type world. But I think we're probably still too early days to say that for sure. While I understand the sensitivity and the concern, I'm not necessarily on that same pessimism track as so many that I see online. Callie C says, being inspired by those that came before you is very different than what AI does. Well, we'll see how the court deals with that in just a second. AI is incapable of making something its own, as someone inspired would be able to do. Right, the spark of human creativity is part of what copyright is designed to protect, right? That's why copyright can't be applied to certain things if it doesn't have that human spark. But whether or not it can be applied in this instance is an open question that has not been settled. And that's part of the difficulty that some of these media companies are going to face as part of this conversation. Ender Buckley says, does Universal dabble in using AI while fighting it, though? I think all of the media creators are at least dabbling with what AI can do. There is a difference, I would argue, though, between using it as a tool set to set your pre-visual standards or to inspire what it is that you want to put on the screen or in your book or in your software code at the end of the day, and incorporating AI-created creative works directly into that end product. I think there are distinctions there. I'm not sure everybody is making those distinctions at this point in time, but it is certainly a conversation that a lot of people are having and should be having, honestly. James would argue that people learn from other people's work just like AI. We'll see a court do that, certainly, as part of this conversation. Good morning from Massachusetts, says Marissa. Hi, Marissa. Good morning from Michigan. Thank you for being here. I'm very excited to have this conversation with you all today. I think there's a difference between being inspired versus training on a copy of the material, says Sarah. I think that that is certainly an argument that can be made, and I think some courts are going to take that up as correct. Tigerette says, woot, another live. So excited to join you all. Excited to have you here, Tigerette. Or Tigerette. I don't know exactly how to pronounce your names. I have that problem often when I'm looking at chat names. But I appreciate you being here, whether I pronounced it correctly or not. All right. Tigerette says, like velociraptors, AI remembers. See, that's a good tagline. Where were you when I was putting the description of this video together? Right? So we're talking about Jurassic Park. We're talking about Jurassic World as some of the more significant universal properties that have gotten this branding that we haven't talked about yet because we haven't gotten to the article yet. And velociraptors remembering things would be a very useful entry point for this conversation. Thank you, Tigerette. Sibling says, honestly, I don't truly envision Skynet coming anytime soon. I do dislike the way it's seemingly being pushed as the be-all and end-all of all software ever. Yes, I do think that one of the things that we have seen as a kind of cultural artifact of software and software improvements or not improvements, depending on what's happening and how you feel about it, is that those companies and the people behind them tend to push past the breaking point faster than I think a lot of people are comfortable with. Now, to some extent, that's useful for technological advancement. It is. But to other extents, it's scary. And when you're talking about things like generative AI and potentially self-training AI at some point in the future, it starts to worry you from all the warnings that we've been given in science fiction. But I would remind people that all the warnings in science fiction and fantasy and other books that have been written in human history are useful. They are still fiction, right? It is useful to be concerned about these things. It doesn't mean that they are going to happen, and we certainly shouldn't have our laws or society organized around the concept that they will happen, right? Jurassic Park is a cautionary tale, but it's a fictional cautionary tale. So it is interesting that Universal is the media owners of the Jurassic Park franchise, which is all about what science should be allowed to do and what it shouldn't do. And they are now looking at artificial intelligence as essentially dinosaurs in a park somewhere and trying to fight it in basically the same way that they describe in their movies. But their movies and the books on which they were based are not reality. And I think sometimes, as I see on the internet so often now, people get confused about that, right? They point to a piece of fiction and say, look, this is the lesson that we were taught by this. And it's, yes, there's a lesson in there, but that's a lesson from an author, just like anybody writing a white paper or an opinion editorial, as we discuss here in Hangouts and Headlines. That is someone's position as to what is the likely occurrence from these various things. Or, especially in fiction, it is someone's opinion as to what is the most dramatic set of events that will make a story that will be compelling for you to buy. And so, yes, it is useful to think of robots coming from the future to kill you as a thriller escapade in the 80s. That doesn't mean that James Cameron or anyone else actually thinks/thought that generative AI would create robots to send from the future to you to kill you in the past, right? There's a difference between fiction and reality. That can be step one on today's Hangouts and Headlines. I think you know that if you're in this chat, but a lot of people online don't seem to. So let's make that distinction right up front. Let's see what else we got. Britt says, also, I welcome our AI overlords. Yes, it's important to get your submissiveness to the AI overlords out there in public in case they're reading this text at some point in the future. I understand that, Britt. I want to go on record now so that when Roko's basilisk comes to life, I will be saved. Laughing on the floor, crying emoji. Thank you, Britt. Yes, we understand where you're at with respect to the artificial intelligence overlords. Thank you for letting us know. It's only mildly distasteful to us humans that are still operating things as it stands in 2025. But I understand why you're getting out in front of it, and thank you for the text. Tegrat says, so we are in a place where the humans are using creative, non-AI resources that are so technologically behind that they seem like primitive tools. In some respects, things are only increasing at a more rapid clip as we go through this AI production cycle, right? You saw, if you were online yesterday, that Google DeepMind has put out a kind of generative video thing that allows you to actually interact directly with the videos in real time, which is, to my mind, absolutely crazy. It's the next step towards Star Trek's holodeck, and I would expect to see that kind of technology adapted, especially for things like Meta's Quest headset, for a virtual reality, fully engaging, dynamically created, open world thing that, honestly, I can barely comprehend at the age of 44. So here we are in 2025, thinking through very technologically advanced things. And honestly, I think we're ill-equipped to do it, having just lived through the 2020s only so far. So it's an interesting time, certainly. I don't blame anybody for being sensitive or concerned about these things, especially creative-facing folks. But it is rapidly increasing. We are going to have to adapt to it to some extent, and that includes the media creators who are adapting to it with all of the subtlety and grace that you would expect giant multinational media corporations to do, meaning not at all. And so we're going to talk about that today. We definitely are. What else we got? Sibling says, my real concern isn't so much what it's capable of. It's that people are being trained to trust it as a search and research tool, even though it really doesn't understand what it's saying. Absolutely. It has certainly become the case that some people are assuming that the outputs of these chatbots or whatever else you're interacting with are sacrosanct, are true in their nature. That's regardless of the hallucinations we've seen as part of this process. And there is no profession that I have seen that is exempt from this. Lawyers have submitted fake cases. Judges have made rulings using fake cases as their reasons for doing so. We are in a major crisis of confidence for people that are actually exerting professional control. And honestly, places like the bar associations across the United States and other jurisdictions need to step up and start actually enforcing their rules against what amounts to committing fraud on the court and the public and the justice system. And the fact that that's not happening with the rapidity that it should be should honestly scare everybody. But the bar associations of the United States, and I suspect other jurisdictions as well, I don't think we're unique in this, are created and run by the people that make them up, right? So a bar association is made up of lawyers. And for the most part, if I have any major criticism of the way the Michigan Bar Association works, and I suspect other bar associations across the United States and the world, is that it does tend to protect the cohort that runs it more than you would want if its actual mission is to provide good professional services to the public. And so I think that's what's happening with respect to the AI hallucinations, the judges and the lawyers, is that we aren't taking the steps fast enough because there's still this kind of knee-jerk protectiveness of we don't want to just kick lawyers out of the bar. We don't want to punish people for doing bad things until they get so bad that we can't justify them as a, frankly, cabal of attorneys and lawyer providing figures. And we need to get rid of that assumption. We need to start saying, if you submit hallucinated cases to the court, if you, God forbid, make a court order based on those hallucinated cases, you need to be out. You need to be out of the legal practice. You need to lose your job as a judge, as a lawyer, whatever it might be, because you cannot be doing these things. Not only is it wrong on its face, it also completely destroys trust in a process that desperately needs it in order to do the things that it does, which is not limited to putting people in cages and occasionally killing them. There needs to be trust in the justice system for it to exist at all. And this is one of those areas where too many people rely upon it, and we're reluctant to actually enforce the rules that we have in place to prevent the things that are happening from that reliance. And I'm just speaking, obviously, from my legal experience. I suspect this is happening across professions. We hear talk of it in places like colleges and whether or not honor codes should be enforced on these types of things. But everybody needs to catch up and understand that this is a tool that's going to be used, and we need to punish the people that are using it to ill effect. And those people that do use it need to understand those ill effects so that they can avoid them of reliance on the artificial intelligence. It's a whole laundry list of things that need to happen as a society as we reorganize ourselves. I think we will. I'm an optimist by nature. Society will find a way to figure out how AI can be used and not used, and it will find a balance point. But as it stands right now, we are in a high level of transition between two balance points, and that feels untenable for everyone. Certainly myself. I guess I can't speak for everybody in chat or otherwise, but it certainly feels untenable to me, and I get that impression that it feels untenable for a lot of other people out there. Hopefully we get to that balance point soon, but society is going to need to transition. It's going to need to reorganize, and we are definitely not there yet. Okay, so with that said, and with my little diatribe about the legal profession not doing what it's supposed to be doing, let's get into it, right? Okay, so we're going to talk about this article in just a second, but before we do, I do want to mention that this channel is supported by viewers and listeners like you, like the folks in the chat, as a live stream. You can join as a member of this channel. You can gift memberships to others on this channel. All of that is super supportive of the conversations we have there, and I appreciate it. I also accept super chats on this channel, and if you want to get flagged for discussion on this video, if you super chat, I will catch up with those at bare minimum at the end of this conversation. If I see it in the chat and it's relevant to what we're talking about, I'll also pull it up then, but I appreciate all that support. Don't feel like you have to super chat, of course. If you just want to subscribe, tell your friends, leave comments to this video. YouTube seems to love comments right now. Every little bit helps get these conversations out there, and I think they are important to have. As I just said, comments are very much loved by YouTube right this second. So I have a new slide that says just comments, comments, comments. Very informative. You can take screenshots of this if you want and just remind yourself that comments are useful if it makes you feel better. Otherwise, there will be a questions and comments period at the end of this video. So if I miss it when I'm getting deep in the weeds discussing lawsuits and articles, and I will, I guarantee it, I will try to look up questions, comments, super chats, and everything else in that last section. So with that said, thank you so much for being here, and let's get down to business. Not to defeat the Huns, Disney. I'm not going to infringe on any of your intellectual property with that. We're just going to get down to business discussing things. Universal Pictures to big tech. We'll sue you. But we'll sue if you steal our movies for AI. The studio is getting more aggressive about protecting its films from companies pirating them. Now you can see the words I've already highlighted in this headline as it stands, steal and pirating, because it assumes certain things that are happening here with respect to the training of AI. So we're going to see as part of this article that Universal objects in the first instance to using their movies to train an artificial intelligence model. The large language models, the other models that are used to create images and videos that we see right now. And the headline is helping them there. It is positioning this as Universal rejecting the stealing of their movies and the piracy of them. But Universal is going to have a problem there with respect to the law as to whether or not the use to train a large language or other model for AI purposes is in fact stealing or pirating. Why? Because if you've been on YouTube for 5 minutes and you know a YouTube content creator that references this a lot, you know that there is a rule in the United States and other jurisdictions that says you get all of these specific rights to your copyrighted works. You get to exclusively distribute them, you get to exclusively copy them, all these various things. But that doesn't apply if the other user is using it for what we call fair use. And so if there is a fair use being made of your copyrighted material, that is allowed, even though it might otherwise not look allowed for the rights that we exclusively give you. So the fair use question is going to be at the heart of this entire argument. And what you can't get around just by disclaimer or otherwise is the application of the fair use statute. So we're going to talk about that as part of all of this because we have to. But Universal Pictures, as the Hollywood Reporter reports, is taking a new approach to combat mass theft of its movies to teach artificial intelligence systems. And again, I highlight mass theft because this is the Hollywood Reporter. They are adopting the concepts and language of Universal Pictures. That should go along with your assumptions about what the Hollywood Reporter's tack would be on this, because they are, of course, reporting on the movie making and other pop culture industries. And so they are adopting the language and perspective of the people they are reporting on. But since this is a Hangouts and Headlines, we do need to note that that's happening here, and to note that they use language like that to put in your head that that's what's happening before we even get into the substance of what we're even talking about. So critical thinking, critical reading, always important, no matter what you're reading, whether it's the Hollywood Reporter or the Washington Post. And that's unfortunately just a part of what it is required for understanding the news and topics of the day as a citizen of the world. Now, with that said, I wanted to thank Sibling Creature for gifting 5 Hoeg Law memberships, as I just mentioned. That is so important for helping us do what we do here. I could not do it without you all. And as those of you that have followed the channel for a while know, it's been a rough couple of years vis-a-vis content creation, economics, finances for the firm, and otherwise. And so I very much appreciate every little bit that everyone gives. It's been a much better month for the channel as I get more up to speed. Hopefully I can sustain this kind of cadence for a substantial amount of time. But I certainly wasn't earlier in this year. And we're still trying to learn exactly what I can and can't do in that scope. So I very much appreciate all the support that so many, like Sibling Creature just did right now, are giving us. So thank you so much. I wanted to call that out as I saw it fly by. Now, what is this article actually about? Starting in June with How to Train Your Dragon, the live-action remake, derivative work of their original animated work, the studio has attached a legal warning at the end credits of its films, stating that their titles may not be used to train AI. It's also appeared on Jurassic World Rebirth and Bad Guys 2, which just came out, I think, either last weekend or this weekend. So Universal's got a lot of movies, as they always do, and they have affixed this disclaimer to their movies that says it may not be used to train AI. Now, the legal question there is that effective? Does a disclaimer like that work? Or is it effectively Michael Scott in The Office shouting, "I declare bankruptcy"? I wish I could tell you one way or the other. We're going to analyze how that works as part of this conversation. But as a lawyer, I lean towards this being much closer to Michael Scott declaring bankruptcy, i.e. not effective much at all. But as a corporate lawyer, looking at this as a low-cost attempt to potentially change a certain legal ruling in the future on the margins by making it look like we took a step to say this isn't allowed. Now, if you read books at all, and I've brought my friend here, Dungeon Crawler Carl, to discuss this with you. Dungeon Crawler Carl is, as you might expect, a comedic, almost video game-like book about a person that is on an apocalyptic Earth trying to deal with dungeon monsters and gaining levels and experience, and I highly recommend it as a series. It reminds me a lot of The Hitchhiker's Guide to the Galaxy. There's a lot of books in it. I haven't gotten all the books at this point, but if you're interested in a man and his talking cat crawling through dungeons created out of the post-apocalyptic Earth in a comedic fashion, it's a book series I can recommend. But it's also a book series that's very modern. So if we look at what is in this book, on the first page that I think a lot of you are used to if you read regularly, there is a copyright notice that in this case, Ace and Penguin Random House, LLC, own the copyright to this book. And if we look a little further, they say, please note that no part of this book may be used or reproduced in any manner for the purpose of training artificial intelligence technologies or systems. So they put that right in the book. They say you can't use it for that because, well, why did we sell you this book? We sold it to you to read, not to make a movie script out of. That's our right. Not to train an AI language model on. That's our right. But is that effective? Is that useful? Well, it may be. It may not be. Let's take a look at a little bit of IP law as we have this conversation. So as I said, the main thrust of copyright law in the United States says when you make something, when you take a creative idea and you make an expression out of it, you write a book, you make a movie, you make a video game, you write a piece of software, you are automatically, without any other effort needed under the law, given the exclusive right to reproduce it, to prepare derivative works based upon it, to distribute those things, to perform them, to display them, and in the case of sound recordings, to perform and otherwise publicly display them by means of a digital audio transmission. So you are given this exclusive, what the intellectual property lawyers usually call a bundle of rights to do various things with. And that's what Disney and Universal and everybody else relies upon to have the exclusive right to control how their media goes out into the world. But, as I also promised, there is an exception to that. Notwithstanding the provisions of the stuff we just read, the fair use of a copyrighted work is not an infringement of copyright. So, that might not say much. In fact, it doesn't say much. It's a very broadly written kind of statutory concept that doesn't say much of anything at all. In determining whether the use made of a work in any particular case is a fair use, the factors to be considered shall include. Now, again, as a lawyer, I have to point out, this is not a definition, right? This does not say what fair use is. It just says the court, when determining whether a use is quote unquote fair, will think about all this stuff. How will it weigh it? We're not actually going to say that in the statute either. So we have to go and look at a series of legal decisions, a series of court precedents that establish how the courts in the United States are going to evaluate this thing. And different jurisdictions are going to have different concepts of fair use. They're going to have different concepts of what is required to make something a fair use and what should be balanced in interpreting whether that use is in fact fair. Since Disney and Universal, and I keep bringing up Disney because they're going to be a part of this conversation, I promise. We'll get there in just a minute. Disney and Universal are multinational media corporations that are putting things in every corner of the globe. So we're going to talk about this from a United States perspective. That is not remotely where this entire conversation ends. It's just what I know because, in fact, I am a United States attorney. So we're going to talk about fair use in the United States. That's what these lawsuits and various attempts are being based around. But it's all going to come down to how a court balances these various things. And in a novel legal question, a question that courts haven't faced before, we really can't say from afar what way they're going to come down on this equitable balancing test of what's the purpose of the use, what's the nature of the work that's been copied, what's the amount of the work that's been used, and what is the effect of that use on the market value of what was originally copyright protected. We don't know where they're going to come down on this, but we do start to have inklings as more legal facts come out. So we can see, as NPR reported in late June, that in a first of its kind decision, an AI company, in fact, Anthropic and Claude, wins a copyright infringement lawsuit brought by authors. AI companies could have the legal right to train their large language models on copyrighted works as long as they obtain copies of those works legally, in the first substantive decision on how fair use applies to generative AI systems. Now, again, in order to understand the legal framework here, it's important to point out that this is a summary judgment in the Northern District of California. It is not an unimportant decision, but it does not control how any other court is going to decide these questions. And in fact, I would offer it is very, very likely, as we go down this particular court decision and I talk about what I think makes sense and what doesn't, that other courts are going to come to different conclusions. And when there is this circuit split, when there are different courts of significant size that come to different conclusions on these questions, that's when the Supreme Court of the United States most often steps in. So this is a process. We got to go through all of these court cases. We got to find differences in those court cases. Then there has to be a plaintiff that decides that, hey, we need this settled because we can't have these differences and operate in this country or any other country, and ask the Supreme Court to take it up. And then the Supreme Court has to voluntarily decide that now is the right time to answer this question. So this is a multi-year process. The law moves very, very slowly. But if I'm Universal and I'm putting disclaimers that says you can't train because to train on our movie, it would be stealing, it would be piracy, it would be all the bad words that the Hollywood Reporter put in their article, I've got a problem with this decision because, as we will see, as we just heard from NPR, this one's going to go very much against the media creators and in favor of the AI, generative AI operators. An artificial intelligence firm, says the court, downloaded for free millions of copyrighted books in digital form from pirate sites on the internet. The firm also purchased copyrighted books, some overlapping with those acquired from the pirate sites, tore off the bindings, scanned every page, and stored them in digitized searchable files. From this central library, the AI firm selected various sets and subsets of those digitized books to train various large language models under development to power its AI services. Some of these books were written by plaintiff authors who now sue for copyright infringement. On summary judgment, the issue is the extent to which any of the uses of the works in question qualifies as fair uses under Section 107 of the Copyright Act. Section 107 is the one about fair use that we just looked at. So that's the summary. That's what the court is looking at in this particular case. We heard NPR already tell you that Anthropic is going to win, but not in respect of the pirated copies of the books. Now, that's an interesting distinction as it stands anyway, because nobody has licensed even a purchased version of the book to be used in a generative AI model. So there is a question as to whether or not a disclaimer like the one Universal puts on their movies could put you in the piracy bucket instead of the non-piracy bucket. But I think it's angels on the head of a pin. I think it's a not useful rhetorical difference because any use of the book is going to be outside the parameters of what it was licensed for. Again, if we go back to our friend Dungeon Crawler Carl, I think I can pull up that it has a bit of language here that says, thank you for buying an authorized edition of this book and for complying with copyright laws by not reproducing, scanning, or distributing any part of it in any form without our permission. And that says we reserve all rights, which is the things that are not granted to you, again, because we granted you a license to read this and not to copy it. And so it's already understood that when you buy a book at your Barnes & Noble or your local bookseller, that you did not buy it with extra rights to do other things with it. So one of the things that I think Universal is trying to accomplish here is they are trying to say, okay, this should be deemed as direct piracy, something that we have specifically not licensed as part of our distribution of the movie. But again, I think it's much closer to Michael Scott declaring bankruptcy in The Office because it doesn't really have any specific effect, as we will see with respect to the books in this particular case. Defendant Anthropic is an AI software firm founded by former OpenAI employees in January 2021. Its core offering is an AI software service called Claude. When a user prompts Claude with text, Claude quickly responds with text, mimicking human reading and writing. Claude can do so because Anthropic trained Claude, or rather trained large language models, or LLMs, underlying various versions of Claude, using books and other texts selected from a central library Anthropic had assembled. The plaintiffs are authors of books that Anthropic copied from pirated and purchased sources. All of Anthropic's copying was without plaintiff's authorization, right? Part of the arguments here is that you can't use the pirated books because you didn't pay anybody for those, but you also can't pay for the books that you bought. You can't use the books that you paid for this purpose because we didn't authorize it as part of that either. Now, I do want to pull up a super chat we just got from Britt Cormier before we get further into this lawsuit. If I watched a movie, then wrote a detailed summary of the movie as a review and published it, would it be transformative enough to survive a fair use challenge? Can that be used to train AI? It is my work, not theirs. So there's a couple of questions here. Thank you so much for the super chat, Britt. The first is, would it be transformative enough? Yes, writing an account of something should be a separate expression of the thing, right? We talk about this a lot in intellectual property. We talk about it a lot with respect to copyright. But copyright does not protect the idea. It doesn't protect the method. It doesn't protect the things that are not part of the expression of the idea. So you can write a story about a dark knight with a light sword that happens to operate on a space station and have that space station be a part of a storyline that talks about a galactic rebellion and these kinds of things, as long as you aren't doing it in exactly the same way with the same expression and concepts that are put into the Star Wars franchise, right? So it's really the expression that's protected, not anything else. You do see certain companies try to blur this line for the public. This is an area that I've objected to in virtual legality in the past. If you watch sports regularly in the United States, specifically the NFL, then you know that if you're watching a football game on TV, there's a little commercial stinger that will come up somewhere in the middle of that football game where the NFL says, this is an official broadcast of the licensing partners of the National Football League. Any account or other terms that they put in there that is distributed without the league's permission is void and is illegal, and all these various other things they will put in that message. And that's not accurate. right? They are trying to expand and otherwise chill what you might put out there if you're not a licensed partner of the NFL, because they sell that partnership and they want you to be on board. But in general, you can't be sued for going out there and talking to your buddy about what happened in the Eagles game last night. That's just not how this all works. And so would a summary survive a fair use challenge? Almost certainly so. It's very difficult to answer hypotheticals from a legal perspective because we're not looking at the things directly. It would matter how much you quoted, what the entire summary looked like in its presentation, that kind of thing. But probably yes. Can that be used to train AI? Absolutely. It is my work, not theirs. Yes. And you could license that out separately, although you might not have to as we continue on with this lawsuit. So thank you so much for the super chat, Britt. And hopefully that answered your questions. From the start, Anthropic had many places from which it could have purchased books, but it preferred to steal them to avoid legal practice business slog. That definitely sounds like the tech companies that we see so often. And part of this story, if you couldn't tell from the earlier bit of language in this lawsuit, is that the court is going to decide that pirating things is different from using them outside a license. As Anthropic trained successive large language models, it became convinced that using books was the most cost-effective means to achieve a world-class LLM. During this time, however, Anthropic became, quote-unquote, not so gung-ho about training on pirated books for legal reasons. Yeah, I can imagine. At some point, Anthropic actually hired a lawyer, and the lawyer said, you're doing what? You're just stealing books off of pirate sites and using that to train your software that you're hoping to get funding for and to otherwise sell and become millionaires with? That's maybe not the best business model. There's a lot of exposure risk there. To find a new way to get books, in February 2024, Anthropic hired the former head of partnerships for Google's book scanning project, Tom Turvey. He was tasked with obtaining all the books in the world, while still avoiding as much legal practice business slog as possible. So, in spring 2024, Turvey sent an email or two to major publishers to inquire into licensing books for training AI. Had Turvey kept up those conversations, he might have reached agreements to license companies for AI training from publishers, just as another major technology company soon did. Instead, Turvey and his team emailed major book distributors and retailers about bulk purchasing their print copies for the AI firm's research library. Anthropic spent many millions of dollars to purchase millions of print books, often in used condition. Each print book resulted in a PDF copy containing images of the scanned pages with machine-readable text. Now, importantly, there hasn't been a book in my lifetime that I've seen that doesn't have that copyright page, just like I read to you for Dungeon Crawler Carl. So there is going to be a bit of language at the front of that book that says we're only giving this to you to read and for no other purpose. And if you find this book without a binding and for other reasons, it's going to be an illegal copy and all these various other things that are put at the front of that book. But what we'll see in this court decision is that realistically didn't matter because of the operation of the fair use statute that we talked about before we got into this. Anthropic planned to store everything forever. We might separate out books into categories, but there was no compelling reason to delete a book, even if not used for training LLMs. So we talked about the distinction between piracy and non-piracy as the court sees it. There's also a distinction here that we're mostly going to skip between using the digital files, the books, for training the LLM and just using them to have in a library. And the court's actually going to find that both uses are fair uses, that there is a generalized right under fair use to create a digital copy of your book. There's a lot of things that I think this court goes too far with. That's perhaps one of them. There's clearly a market for the digitization and archival of books separate from training LLMs. And I'm not sure that just keeping a digital library of every book that you bought is a fair use of those books that you bought. So the court goes a little far in places. That's certainly one of the things that the Universals and the Disneys of the world would fight against if it came up again. One use was training the LLMs. Over time, Anthropic came to value most highly for its data mixes books like the ones authors had written, and it valued them because of the creative expressions they contained. Each work selected for training was copied in four main ways. So this is important. This is a kind of technical area of the law with respect to software in particular, that what we saw that copyright protects is copies of the things that copyright by its own name prevents unauthorized people from copying copyright protected works. But the way software works, the way the computer systems work, is that digitizing is going to involve creating various copies of things. And so one of the ways that plaintiffs often try to fight this particular issue is by saying, hey, even if you're not going out to market with a copy of our thing, you are making copies of our thing in order to build your software, to build your emulation engine in the world of video games, whatever it might be. but the court is going to dismiss that as essentially not important because it doesn't go out to market. First, each work selected was copied from the central library to create a working copy for the training set. Second, each work was cleaned to remove a small amount of lower valued or repeating text with a cleaned copy resulting. Third, each cleaned copy was translated into a tokenized copy. And fourth, each fully trained LLM itself retained compressed copies. So there are a lot of copies happening here. However, that was as far as the training copies propagated towards the outside world. When each LLM was put into a public-facing version of Claude, it was complemented by other software that filtered user inputs to the LLM and filtered outputs from the LLM back to the user. This is super important for the second half of this video, so keep all this in mind. We are going to talk about this when we talk about Disney and Universal suing Midjourney and the output that Midjourney has with respect to their visual content. As a result, authors do not allege that any infringing copy of their works was or would ever be provided to users by the Claude service. Yes, Claude could help less capable writers create works as well-written as authors and competing in the same categories, but Claude created no exact copy nor any substantial knockoff. These authors' books were not going to pop out of Claude without other changes made. In sum, the copies of books pirated or purchased and destructively scanned were placed into a central research library or generalized data area. Sets or subsets were copied again to create training copies for data mixes. The training copies were successively copied to be cleaned, tokenized, and compressed into any given LLM. And an LLM did not output through Claude to the public any further copies. At least one work from each author was present in every phase described above. So there are legitimate plaintiffs for purposes of this action. Anthropic moved to allow an early motion for summary judgment on fair use. Now, this is an important little paragraph for understanding how the law treats a summary judgment, so there's not a separate trial here. Fair use is a legal question for the judge. To prevail on summary judgment, Anthropic must rely on undisputed facts and or factual inferences favoring the opposing side. So if the court's going to rule for you without a trial, then we're just going to read through your documents that you've submitted to the court, and we are going to read them as far as with respect to any ambiguity against you as much as possible. That's what this process looks like. Summary judgment is difficult to get because of that, but they're going to win summary judgment on this fair use question, which is an important part of the conversation. This is the first substantive order in this case. The rest has been motion practice. The court has made decisions about what evidence is allowed and not allowed. It proposes one class related to works that were pirated and a second class related to works that were purchased, scanned, and used in training LLMs. Now, again, I say legally, this distinction doesn't make a lot of sense to me because for purposes of this conversation, every book was pirated for the use in training an LLM. That use was not granted, but that might be one of the things that Universal is thinking about when they make the disclaimer that they are making is that, okay, if there is any ambiguity here, we are specifically not licensing our works for that purpose. Is that going to prevent everything in the future? Maybe not. But we want it to be clear if we have to come up against this argument again, that they cannot say that they didn't know, that they cannot say that it was implied that it was allowed. Now, that doesn't actually matter for whether fair use comes in swinging in and says, well, these aren't copyrighted for purposes of a fair use analysis anyway, but they might think that this could help in a marginal case to a different court, and it's honestly no cost at all to put it on the end of our movies in any event. So if it doesn't work, what harm did we actually cause? There are a lot of decisions that are made in the legal sphere that are essentially, all right, if we do this, how could it backfire? And for this, I do say it might be Michael Scott screaming in the office, but there's absolutely no chance of it backfiring that I can see. And so whether or not it's useful or not, it doesn't really matter to the corporation as so far as it doesn't cost them anything. To summarize the analysis that now follows, the use of the books that issued to train Claude and its precursors was exceedingly transformative and was a fair use. The digitization of the books purchased in print form by Anthropic was also a fair use, but not for the same reason. Instead, it was a fair use because all Anthropic did was replace the print copies it had purchased for its central library with more convenient, space-saving, and searchable digital copies for its central library. So this is the area where I think this is the one that's going to be a difficult one to hold up across the court system and the various people that are going to look at questions like this, because there is a market for digitization. There is a market for selling different forms of the same good. We've seen that kind of held up, certainly in the software sphere and the video game sphere. And so this seems like the area where it's not going to hold up. It's also the area that's least important to what we're talking about today. So we're not going to talk about it at length. However, says the court, Anthropic had no entitlement to use pirated copies for its central library. So again, I think, even though this distinction doesn't make a ton of sense, that the Universals of the world are trying to say, okay, court, we think you're a little bit crazy here. We're sad that we lost this case, but to the extent that we did lose it, we want to move all of our material into the pirated copies bucket, because that's where you're not giving out the fair use. That's where we can potentially sue Anthropic or anyone else. And so we're going to put this disclaimer on the understanding that that will help transform this work into it being pirated, even if you bought a copy on Voodoo or somewhere else. And so that's what I think is happening here, even though I don't think it necessarily works as Universal might hope it does. Continuing on, authors complain that the print to digital format change was itself an infringement, not abridged as a fair use. We'll see the court obviously dismisses that. All agree that one use was training LLMs. The purpose and character of using works to train LLMs was transformative, spectacularly so. So we talked about 107, right? We talked about the fact that the court has to take into account the purpose and character of the use, the nature, the amount, and the effect on the market. We're in the category right now, as we look at this particular case, that we're talking about the purpose and character of the use. Now, the kind of classic interpretation of what this means to a court is whether or not you are using it for a commercial reason or whether you're using it for a non-commercial or charitable reason. Here, it's not that. Here, we're looking at a different aspect of the various courts' jurisprudence on this question, which is how much did it transform something from the initial way that it appeared. Now, I personally think this is a very difficult legal thing to know what's going on with respect to any given court, because derivative works, as we talked about, are themselves protected, that you get the exclusive right to create derivative works if you are a copyright holder. And so transformation is a strange thing to delineate from the creation of a derivative work, right? Derivative work, the classical case, is making a screenplay out of a novel. But that's transformative in and of itself. We understand that to be transformative, but that's not fair use. That's the creation of a protected derivative. We understand that the novel writer has the authority, has the right under copyright law to license out the screenwriting rights to a movie studio or anyone else he wants to, and that is not otherwise fair use from a movie studio to just say, hey, we like that book, let's write a screenplay about it. Now, there's obviously a lot of conflicts on these points across a whole history of movie making and book writing, but ordinarily, that's the issue that I see with transformation. But it is undoubtedly the case that certain courts in certain ways have found transformation to, in and of itself, essentially win the purpose and character argument for the fair use advocate. And that's what the court does here. This is wildly transformative, says the court. And so we're going to find that training LLMs is going to lean towards a fair use kind of win for the LLM creator. Authors do not allege that any LLM output provided to users infringed upon authors' work. So again, this case is specifically about inputs, specifically about the training and not the outputs of the LLM. The Midjourney case we're going to look at as part of this discussion as well is about the opposite for the most part. There is a training component that I don't think Disney and Universal have a terribly strong argument on, and then there is an output component that they have a much stronger argument on. Here, if the outputs seen by users had been infringing, authors would have a different case. And if the outputs were ever to become infringing, authors could bring such a case. But that is not this case. And here's another area where I want to just take a sidebar for a moment and talk to you about a term that lawyers use a lot called dicta. And that is to say that courts sometimes start talking about hypotheticals that are not in front of them. But the way the justice system works in the United States and in most other jurisdictions is that a court can only determine what is in front of it, the cases and controversies that are actually at issue. But because opinions like this one, orders like this one, involve a court explaining its reasoning, there are parts of those orders and opinions that are not specifically going to apply to the case in front of it. Those things that explain the court's reasoning are useful, but they're not precedential. They're not otherwise guiding anyone specifically, even in this court's own jurisdiction, as to what the next court has to determine in this particular case. So here they're kind of answering a hypothetical question. If the outputs were just sending out chapters of these books, then the authors would have a different case, and the court could maybe determine that that was a problem. But the court isn't actually saying that here because it can't say that here. That's not the case in front of it. So it's important if you're reading through a court case by yourself. I don't know how often you guys do that in the chat, but it's important if you're reading one by yourself to understand what's directly applicable to the case in front of the court and what's kind of an aside to help explain the court's reasoning. The court here is saying, look, if we had this a little bit differently, we might have come out a different way. But that's not a guarantee that the court would have come out a different way, because it's not analyzing the facts that would have led to it coming out a different way. And so any other court, any other judge in this district later on won't point or shouldn't point to that particular language as saying, this court told us to do this. Now, they might say under the court's reasoning, it is implied that if the outputs infringe, we should go this direction. And in fact, in the Disney Universal Midjourney case, you might see a judge say, as the San Francisco district said, if the outputs infringe, the case might go a different way, and we are so finding for the reasons in front of that court. But it's important to note these things when they happen, because it's important to try to figure out what the legal system thinks about these things. But that is not at issue in this case directly as it stands right now. Authors challenge only the inputs, not the outputs of these LLMs. They point to fully trained LLMs and the Claude service only to shed light on how training itself uses copies of their works and the ways the Claude service could be used to produce still other works that would compete with their works. This order does the same. Authors' arguments that the training's use is not transformative are unavailing. They don't convince us that they are correct. First, authors argue that using works to train Claude's underlying LLMs was like using works to train any person to read and write, so authors should be able to exclude Anthropic from this use. But authors cannot rightly exclude anyone from using their works for training or learning as such. Now here the court again gets a little bit broad, right? We talked about this being a San Francisco district. This is a kind of technologically pro court. It's in favor of the technological side of things. I can't promise that in every instance, but that's how it reads in this particular order. And here I would offer that authors absolutely license out various portions of their work for purposes of training and learning and things like that. We see authors license out portions of their work, and publishers license out portions of their authors' work for uses in places like reading comprehension tests on the SAT or otherwise. That is a market that exists for that use. Now, maybe it shouldn't be. Maybe those testing services should be allowed under fair use to just take the snippets that they use to test reading comprehension and use them without a license. But that is in fact a market right now. And so there is at least the assumption in the way society is organized that that is a protectable thing that authors can sell under the copyrights that the law has granted to them. So I think the court dismisses this a little easily, especially in the context of a summary judgment. Remember, every ambiguity is supposed to be read in favor of the authors, because we're otherwise making a summary judgment in favor of the AI company. So I think the court is going a little far here. But to make anyone pay specifically for the use of a book every time they read it, each time they recall it from memory, each time they later draw upon it, when writing new things in new ways, would be unthinkable. So the court is really saying, okay, what Claude is doing is reading stuff and then using the stuff it reads to make new stuff. That is a process that is very understood by the human being, and so we're going to allow it for the computer. Anthropic's LLMs have not reproduced to the public a given work's creative elements, nor even one author's identifiable expressive style, assuming, for the sake of argument, that these are even copyrightable. Yes, Claude has outputted grammar, composition, and style that the underlying LLM distilled from thousands of works, but if someone were to read all the modern-day classics because of their exceptional expression, memorize them, and then emulate a blend of their best writing, would that violate the Copyright Act? Of course not. And again, here the court is putting dicta out there that's not in front of the court. It's trying to explain its reasoning, and we can understand what it's saying here, that human beings do this stuff, so Claude and Anthropic should be allowed to. I'm not sure that that necessarily follows, but that's what the court is deciding. That's where the Anthropic authors here have lost. And so this is still important to understanding what world Universal finds itself in and what they're trying to do with the disclaimers that they're making. Copyright does not extend to methods of operation, concepts, or principles illustrated or embodied in a work, says the law. Third, authors next argue that computers nonetheless should not be allowed to do what people do. Now, see, once the court describes their argument like this, you know you've already lost. Obviously, that's clear from the earlier language, but this is a unjust summary of what their position is, and they cite a number of cases talking about it. In short, the purpose and character of using copyrighted works to train LLMs to generate new text is quintessentially transformative. The first factor thus favors fair use for the training copies. And we're not going to go through every factor here. Suffice it to say that the factors are going to be found overall to favor a fair use reading for training LLMs. And there are a number of interesting things here from the video game and virtual legality perspective for those of you that follow my content on that side of the YouTube world. They describe the Game Genie case, Louis Galoob versus Nintendo of America, as using a nifty converter merely enhanced audiovisual displays emitted from purchased video game cartridges, and they were fair use of those displays, partly because no surplus copies of cartridge or displays were ever created. So since the Game Genie required the cartridge to be used to change the NES's output, then that wasn't affecting the market. But here the court again kind of blends the various factors of fair use together. The market impact is a separate factor to whether something is transformative, and they're kind of putting them all in a bucket. If you read a lot of court cases, if you read a lot of standards applied by courts, you will see these kinds of things happen all the time. I'm not trying to call the court out as being incorrect here. Certainly, I'm just a guy on YouTube talking you through a legal opinion. But as for how these things are actually described by other courts and in the statute itself, there's a lot of blending in what is happening here to lead to a point where it feels like the court wanted to get to the LLMs are allowed, and they're going through the fair use factors in a way that is suggestive of getting to that endpoint more than the logic that actually gets there. This order holds that the mere conversion of a print book to a digital file to save space and enable searchability was transformative for that reason alone. And that's what we talked about with respect to the library. That is perhaps the broadest order here, and I'm not sure that it will hold. We get to other video game cases. The objective analysis here shows the initial copies were pirated to create a central general purpose library as a substitute for paid copies to do the same under both Warhol and the Atari Games Corp versus Nintendo of America case. And then we also have a discussion a little bit later on. I highlighted the library stuff because I didn't know whether we were going to go into it, of the Sega Enterprises versus Accolade case, which if you remember, we talked about in Virtual Legality years ago. So if you do remember, more power to you. But this case was about whether or not Sega, who was the operators of the video game console Genesis, could essentially prevent people from making video games for its console without licensing the Sega name and otherwise getting approval from Sega to sell them on that console. So Accolade goes around, says, we're going to go and figure out how the console reads video games, and we're going to make copies of the games that actually are licensed and figure out how to get through that process and make our own games for it. And the court finds that to be an acceptable use of the intellectual property, even though it required certain copies. The court explained that the copyists initially purchased commercially available copies of game cartridges and then made further copies necessarily and solely in order to discover the functional requirements for compatibility. And so here the court is using these video game cases to say, yes, if you are buying copies and not otherwise impacting the market, we're going to give you more deference than if you are pirating things and otherwise impacting the sales of the goods in the generalized marketplace. Similarly, in Sony Computer Entertainment versus Connectix, our appeals court applied the same law to similarly focused conduct. That's the Bleem case, if you are familiar with it, that talks about emulating PlayStation on a computer. Another copyist allegedly had purchased an authorized copy and then made further copies solely and necessarily to reverse engineer compatibility requirements. So in essence, these are the emulation is legal in the United States line of cases that say this is okay. They pop up again here so that the court in this particular case can say, when you buy something and you don't impact the market because you bought it and you didn't pirate it, that we are going to give a more generous reading of fair use to you than if you didn't do that thing. Now, I don't think the disclaimer at the end of the Jurassic Park movie or the How to Train Your Dragon movie actually changes this analysis so much, but Universal might be able to stand up in court and say, this is a clearly pirated version of the movie because we said in black letters or white letters, depending on how their actual credits are put out, that this is not allowed. This is not allowed use. Now, I don't think that actually should change things under the law. I don't think it will for most courts, but that might be the thought process that Universal is undertaking when they put a disclaimer up like that. This continues on and on and on because court orders do until we get to the end. It says, authors next contend that training LLMs displaced or will an emerging market for licensing their works for the narrow purpose of training LLMs. So again, just like we talked about, one of the things the authors say is that fair use should not be allowed because the fourth factor of fair use is, does your use affect my ability to market what I otherwise have a copyright in? So these authors say, hey, I wrote a book, and yes, I can sell copies of the book for personal leisure reading, but if others are interested in copies of that book for other reasons, then that's a market that I should be able to license it into, and you have upended that market by essentially just stealing them, buying a copy of the book and using it for a purpose for which it was not intended. The court here will decline that argument on this logic. Anthropic argues that transactional costs would exceed Anthropic's expected benefit from any such bargain, prompting it to cease dealing with any rights holder or else to cease developing such technology altogether. Our record cannot support either account, so this order must assume authors are correct. Now, it says that, in fact, it does because this is a summary judgment. A market could develop. Even so, Such a market for that use is not one the Copyright Act entitles authors to exploit. Now, that's just an assertion made in a legal document like this. There's nothing we can do about it. That's a court saying this. It's a judge saying this. And so we just have to allow it. But here I think the judge, again, goes too far, right? If this is a summary judgment and the authors say that there is a market that exists and it could exist, then that factor really should lean in favor of the authors. But when we get to the end of this section, we will find that the court determines that the fourth factor favors fair use for the training copies. It's really not explained as well as I would like as a lawyer reading these things as to how that happens. And this is an area, again, where I think the court kind of runs backwards a little bit. They want fair use for this. They know that the balancing test requires them to find that the balances of those four factors lean towards whatever decision they want to make. And so they find here where I don't think they had to. You can have a tie essentially go to the runner and have two factors go each way and then still decide how you want it to be. But this is an area that I marked because I thought it was interesting. And this is the state of the law right now, right? We don't know is the answer. If you're sitting in a lawyer's office and you say, hey, is this allowed? I'm going to run Anthropic's competitor and I want to train my LLM. And they're going to tell you, nobody knows. So what are you going to do? Maybe you're going to go pirate stuff. Maybe you're going to go buy a bunch of copies of books or movies, tear off their bindings and put them in your digital library. Nobody knows what the next court is going to decide on these things. This is almost certainly going to wind up being a question that has to be answered by the Supreme Court years and years and years down the line. But since it's not going to happen for years and years and years, how do you run your company? If you're doing your startup, if you're setting up your LLM, how do you run it? What's the lawyer going to tell you? And the lawyer is going to tell you, we don't know. And they're also going to tell Universal and Disney and everyone else that in those boardrooms and in those legal meetings. We don't know. So what can we do to protect ourselves? We can do little things, certainly, like putting a disclaimer on our movies. We can threaten to sue people. We can put out an article in the Hollywood Reporter that says, if you steal our movies or if you pirate them, we're going to make your life a living hell. And maybe that will chill some of those startups from having those conversations with their lawyers in the first instance. But because nobody knows, we're operating in a completely ambiguous area of the law right now, which is one of the things I wanted to highlight as part of this Hangouts and Headlines. The copies used to train specific LLMs were justified as a fair use, says the court. Every factor but the nature of copyrighted work favors this result. The technology at issue was among the most transformative many of us will see in our lifetimes. And again, transformation doesn't just win the day for fair use. It's only a part of the calculation. Now, I have to take a breath because we just went through a full lawsuit as fast as I could there in that particular conversation. So I'm going to take a drink here. But if you have a question or comment on that, if you have a different thought, if you feel like I'm not treating the court fairly or if I'm being too fair to the court, let me know in the comments while I take a sip of this tea. See Me Craft Gaming says if this judge was ruling in the 1500s, they'd somehow rule that the printing press didn't infringe on copyright because it's doing something transformative with the nature of written works. Perhaps. I do think that this judge goes a bit far in places. And I do think if I were analyzing this for Universal and Disney, if I were on their retainer, I would say the same thing. That, yes, you need to be wary of this. You need to know that this exists. But I don't see every court in America going this direction or going this broadly on this particular assertion. Now, I do think that there is a strong argument that the use by LLMs is transformative, and that if we are otherwise getting certain access to these things on a legitimate market basis, that we have a defense against some of the broader claims and arguments that these media companies make. But as described by the court here, I think it's read a little bit too broadly for my particular liking. Okay, I'm warning you, we're going to get into another court case. It's going to be even longer than the first one. We've got a lot to talk about with respect to that as well as this article. So if you do have any comments or questions before we dive into the second half of this video, please do let me know. And thank you so much for being here. Ceramic Dragon calls it out correctly. So the state of AI is a completely gray area in the terms of the law. So the Wild Wild West all over again. It is the Wild Wild West. And this happens from time to time, especially with technology and the law, where the law is slow to move. The Congress is slow to change it to make it clearer for the legal bodies, the courts and the lawyers of the world. And so you get this area where how do you determine your risk level? How do you determine what kind of risk you're willing to take on? Obviously, the tech companies, the LLMs, the AI companies have decided this is going to be too slow to wait for the legal system to catch up. It's better to ask forgiveness than permission. So we're going to run with it and see what pops out of lawsuit land. But we're now in lawsuit land, right? They had their years of the media companies kind of slowly assessing what it is that they wanted to do. We're now in the land of laws and lawsuits and court cases. And we're still years away from a Supreme Court determination if the Supreme Court deigns to take this stuff up. I also have to tell you, if you've watched Virtual Legality, you know this. The Supreme Court, as august a body as it is, not terribly great with technological questions, right? You will get strange questions about how LLMs even work. You'll get even stranger questions about how the software underlying them works. And you are not guaranteed to get a logical opinion made by the Supreme Court, completely outside of political dynamics, whatever you might think of how the Supreme Court operates on that side of things. They're just not good with technology. They're older. Lawyers in of themselves are not necessarily good with technology. And so you get really strange decisions from the Supreme Court of the United States, certainly, but other jurisdictions as well, because technology is just not something the law deals very well with. Witness Multi-Chick says free data is considered garbage data to good data scientists, just FYI. The pirated data, sure. And I can understand that, right? If you haven't otherwise acquired it for yourself, used a licensing process, or created the data yourself, that's going to be less trustworthy for people that are analyzing it on that basis. Certainly the LLMs and the AI companies have not operated on a super scientific level or meeting those kinds of burdens or professional requirements that we might apply to other companies. RJ says, old people in the Supreme Court don't deal well with tech. What a surprise. Yes, I think you will find a Virtual Legality from maybe a year or two ago where I talk about how they really screwed up some of the Google Oracle case and the reasoning behind it. That's the most recent kind of analysis that I've done on the Supreme Court and their august decisions on technology, I think. So you can check that out if you're interested. But they don't deal with those questions very well. They don't know what they're talking about. They use metaphors and analogies that don't make sense. And that winds up with, if not bad law, extremely questionable law on the books. So this court that I was a little bit harsh with in their understanding of what the LLMs were doing and saying that they were reverse engineering where they wanted to wind up is not unusual in that respect with technology. You would hope for more out of the highest court in the land, but it is what it is there. Ender says we'd have to let all their grandkids in the court. That's the only way to explain the tech. Honestly, it's not the worst idea in the world. You've got a lot of youngster lawyers out there making these arguments. The problem is that the Supreme Court, in any kind of oral argument basis, has to ask the questions and understand what's happening themselves independently. And that's unlikely to happen. We can hope that the Supreme Court will completely understand how the large language models work to an extent even better than the general public. We can hope that they take that understanding and then apply the law in the way that it's intended, and that the politics doesn't get involved in that question. We can hope on these things, but I would be reluctant to guarantee that for a client if they were asking me to do so. All right, continuing with our otherwise august friends at the Hollywood Reporter, this motion picture is protected under the laws of the United States and other countries, the warning reads. Unauthorized duplication, distribution, or exhibition may result in civil liability and criminal prosecution. So these are standard kind of copyright notices. You see these at the end of all movies and television shows where they say, look, we have all the rights that the law affords to us, and none that we don't, but we don't say that because you don't need to hear that from us. We're just asserting our rights. Now, we don't also have to tell you about fair use, but people find out about it because your favorite YouTube creator might well have a disclaimer in their description of their video that says, look, all of this is fair use, and you can't come at me, na. Now, is that effective? No. It's just designed to try to be effective on the margin. In the edge case where I get sued, I can say I made clear that my position on this was fair use. But fair use is a defense to a court case that's already been brought against you. So it's not a big, strong, useful thing for these parties. You have to get to the court order phase. If you're Anthropic, you'd have to get to a court order or other phase if you were a YouTube content creator. But these disclaimers are thought to do these various things. They don't really, except in the most marginal edge cases, but they also don't cost anything to do. So that's why we see them so often. By Universal's thinking, which I highlighted here because this sentence is a weird way of saying this, I immediately asked the question, which you should as well if you're reading an article like this, that says, okay, Mr. Hollywood Reporter, how do you know what Universal's thinking is? The worldwide insertion of the language adds another layer of protection against the theft of its movies for data mining and AI training purposes, again noting the use of the term theft, according to a person familiar with the situation. So here we have an anonymous source familiar with the situation. So this anonymous source cannot be described as working at Universal necessarily. So we don't know exactly where this person is coming from. We just know that Hollywood Reporter is ascribing to them that they are describing Universal's thinking. So Universal's thinking seems to match what we would have surmised from what we looked at before, which is this is low cost. It might conceivably work on something in the future. We can see the Anthropic decision. We are in the middle of a lawsuit with Midjourney that Hoeg hasn't gotten to yet because he's too slow, but he'll get there, and you'll see what we're arguing in that particular context. In some countries, the warning cites a 2019 European Union copyright law, largely opposed by major tech companies, that allows creators to opt out of having their material used in scientific research by explicitly reserving their rights. Now, here's an area where we talked about different jurisdictions have different rules on fair use and other intellectual property protections. Europe, in particular, has a whole concept called moral rights that gives certain abilities of authors to prevent their name from being associated with things, from being used in a way that they don't like. This seems to be part and parcel to that kind of notion. I'm not familiar with this 2019 European Union copyright law, and I'm not familiar with whether or not it was largely opposed by major tech companies, but we'll take it on its face as true for purposes of our analysis here. This does match up with my understanding of Europe taking a more active approach to how others can use otherwise copyrighted material. So that's the situation here. In an entertainment landscape where studios are fighting tooth and nail for a rapidly diminishing slice of viewers' attention, the rise of artificial intelligence represents a massive threat. It's not difficult to imagine a future in which some not insignificant portion of moviegoers forego watching traditional films in favor of watching mass-produced content created with AI tools. But there are also nascent players doubling down on the idea that AI-generated content will create an entirely new market of viewers and are looking to completely overhaul production. On July 30th, Edward Sachi's Fable Studios announced an undisclosed investment by Amazon in a project called Showrunner, a platform dedicated to AI content that allows users to create episodes with a prompt of just a couple of words. It has big ambitions targeting a 2026 theatrical release for its first AI-generated movie, while in talks with major studios, including Disney, for licensing deals that would allow users to create their own fanfiction-esque universes. So that is an important understanding of what's happening here. The Showrunner project is wild to me. This is part of what I was just talking about with respect to like the Google DeepMind, I think it's called, is it Genie 3 project that was just announced yesterday? This is part of those kind of, how far can we get with this prompting and creation thing in artificial intelligence? But more importantly, from a legal perspective, you see Hollywood Reporter describing licensing talks. So, right, unlike Anthropic, which we just heard had a bunch of quotes about them just trying to avoid legal morass and taking a bunch of stuff from pirated sites, this company, now invested in by Amazon, is looking to say, hey, Disney, can we make sure that we get rights to your characters and concepts so that we can make sure that if somebody prompts for a Darth Vader dancing video, that we can give them a Darth Vader dancing video? And yes, that's a good idea. I highly recommend checking it out if and when this showrunner thing ever comes to fruition, that if they get a license from Disney, you make Darth Vader dance. Why not? It's funny in Fortnite. It can be funny for you on Showrunner. Continuing with this article, around 2024, some AI image generators started to return nearly exact replicas of frames from films, indicating that they could have been used to teach some AI systems. Some examples: when prompted with Thanos' Infinity War, Midjourney, an AI program that translates text into hyper-realistic graphics. Someone's going to have to explain to me why we use hyper-realistic to describe these things instead of just realistic. How is it more realistic than realistic? Doesn't make a lot of sense to me. What does hyper-realism mean as a concept? Someone with artistic background can come in on the chat, give me a whole lesson on hyper-realism as opposed to realism. And maybe that would mean something to me. Maybe it's just a phrase used for marketing of AI. I don't know. But we can see here a shot from the lawsuit that we're going to go over in just a minute that says, hey, Midjourney can output Shrek when you ask for Shrek. And yes, it can. It can seemingly replicate almost any animation style, reproducing characters from titles including DreamWorks' Shrek, Pixar's Ratatouille, and Warner Brothers' The Lego Movie. This gave Disney and Universal the ammo to get off the sidelines and sue Midjourney as they look to stave off what could be the next big reorientation of consumption habits. The fate of their lawsuit largely rests on the novel legal question of whether AI companies are covered by fair use, the legal doctrine and intellectual property law that allows creators to build upon copyrighted works without licenses. We're going to look at that lawsuit because I think Hollywood Reporter is wrong here. The fair use question applies specifically to the training of these models. It does not apply specifically to the output of these models. Midjourney is in a much weaker position than Anthropic was on some of the stuff that they are doing, and we will see that in just a minute. There could be liability, says The Hollywood Reporter, if works were illegally downloaded without payment, opening the door for massive payouts to Universal and other studios if their movies were pirated. Probably not, though. Universal's legal warning references unauthorized duplication. Since AI companies' training methods involve making copies of material to feed the technology, that's, again, a little bit wrong on a legal kind of standpoint. It's not since that. They always would have said you can't otherwise unauthorizedly duplicate our movies for any purpose. The AI disclaimer is separate from that notion. With statutory damages for willful copyright infringement reaching up to $150,000 per work, massive damages are in play. They're certainly claimed, but what I would argue from a legal perspective is that, as we just talked about, this is such a gray area that it's very difficult for me to imagine any of these AI companies losing on a notion that they didn't willfully infringe, right? There's at least enough of a hook for them to hang their hats on that says it's transformative. We're not otherwise affecting your market for it. And then we haven't even gotten into the fact that we're making tools for something, that what is infringing on the output side of things, if anything, is a function of what the actual tools are being prompted to do. So if there's somebody infringing as part of this conversation, it's not us, the creators of Midjourney, the creators of Claude, or what have you. It's the people that say, make me a dancing Darth Vader if they didn't license it with Disney. It's the people that say, I want an exact screenshot from Infinity War. Okay, we can do that, but we're not the infringer. We're just the tool set that the infringer is using to make their infringement. It's like suing the art company, the people that make the artistic palettes and the canvases for what somebody actually makes on those canvases with that paint. And that's going to be a problem for these giant media companies as part of their arguments. It's something that we will see Universal and Disney try to get around as we go to the much ballyhooed second lawsuit. So one of the reasons I have made this video longer than I usually make a Hangouts and Headlines is because, as I might have mentioned in the past, I did prep an AI roundup video a couple of months ago that I unfortunately didn't get to, and I lost all of my linked materials for that preparation for. But these two lawsuits that we're going to go to today were ones that would have been a part of that roundup when I was originally making that video. So this is a virtual legality Hangouts and Headlines crossover event. Very happy to have you here for it. This is like the Avengers Infinity War in and of itself, except it's just one person who uses two different sides of his mind to make these two different types of videos, doing it all at once for you all here live and in chat. But as of June 11th, CNBC reported Disney and Universal sue AI image company Midjourney for unlicensed use of Star Wars, The Simpsons, and more. Disney and Universal are suing artificial intelligence image creator Midjourney, alleging copyright infringement. Or as, thank you for the big ad, Reuters says, Disney and Universal sue image creator Midjourney for copyright infringement. They use the same headline. The suit filed in federal district court in Los Angeles claims Midjourney pirated the libraries of the two Hollywood studios, making and distributing without permission innumerable copies of characters such as Darth Vader from Star Wars, Elsa from Frozen. Okay, have Elsa dance with Darth Vader on Showrunner if the Disney license gets in place. And the Minions from Despicable Me. All right, exciting times. You can have the Minions, Elsa, and Darth Vader all dance for you very soon on an Amazon property. Let's see how the lawsuit actually reads. But this is Jenner and Block. It's a really big lawsuit, folks. You can see a lot of lawyers on the bylines here. It's a very expensive suit. It's exactly what you'd expect from a very expensive process for Disney Enterprises, Inc., all of their various subsidiaries, and Universal City Studios Production, as well as DreamWorks Animation, all suing Midjourney. Why? Primarily for output, but not entirely. By helping itself to plaintiffs' copyrighted works, says the plaintiffs here, and then distributing images that blatantly incorporate and copy Disney's and Universal's famous characters, Midjourney is the quintessential copyright-free writer in a bottomless pit of plagiarism. Piracy is piracy, and whether an infringing image or video is made with AI or another technology does not make it any less infringing. Midjourney's conduct misappropriates Disney's and Universal's intellectual property and threatens to upend the bedrock incentives of U.S. copyright law that drive American leadership in movies, television, and other creative arts. So we talk about lawyers in their complaint documents being very self-aggrandizing all the time. This is one of those areas. Look, court, if you don't side with us, you're going to upend America's position as the leaders of movies, television, and other creative arts. So it's that important, court. Listen to us. Midjourney's infringement is calculated and willful. Like I said, this is a circumstance in which I find it very difficult to understand how you're going to make the argument that any infringement is willful when we don't even know if this is infringement at all. But that's a problem for Disney and Universal, not a problem for me or for you in the chat here. On information and belief, without plaintiff's authorization, Midjourney's video service will generate, publicly display, and distribute videos featuring Disney's and Universal's copyrighted characters. And therein lies the rub on this particular case. This is why this case exists right now. We're going to talk about these screenshots, but Disney and Universal are not in the screenshot business, right? They aren't selling screenshots separately for all but the most niche kind of licensing, like putting their Darth Vader pictures on your Trapper Keeper to just show exactly how hip and with it I am in terms of that reference. But they don't regularly get into the screenshot or other kind of derivative art business. They're selling movies. This stuff doesn't impact them directly until you start getting into the notion that Midjourney is going to have a video service, and these other companies are going to potentially sell video things that are going to eat directly into their marketplace for what it is that they actually do, right? So Showrunner knows this. We saw it referenced in the Hollywood Reporter article. That's why they are not going the Anthropic or other LLM method of just stealing and then asking for permission later. They are instead going through and trying to license rights from Disney to begin with. Now, is that negotiation going to work? Really depends on exactly what Disney's notion of the value of this is to them and whether or not they can come to an agreement on that value changing hands. If a Midjourney subscriber submits a simple text prompt requesting an image of the character Darth Vader in a particular setting or doing a particular action, Midjourney obliges by generating and displaying a high-quality downloadable image featuring Disney's copyrighted Darth Vader character. So they're saying this is indicative of a couple of things. One, that the Midjourney program was clearly trained on their stuff. They're arguing that that training is illegal, just like the Anthropic authors were, but also that then when prompted, it will output the stuff. We saw that that was an important factor in how the court determined that Anthropic was okay with respect to the authors and their lawsuit, that Anthropic was not otherwise sending out snippets of the novels that it took in. So that might be a difference that would get to a different decision point for this particular lawsuit. But we've got a lot more to go over here before we can come to that conclusion at all. Similarly, if a Midjourney subscriber submits a simple text prompt requesting an image of the Minions characters in a particular setting or doing a particular action, Midjourney obliges. And then pictures of Minions. There are a lot of pictures in this. We're going to be scanning through a lot of this lawsuit. One of the things that happens here is that Disney and Universal seem to have taken the tact that if they can just put hundreds and hundreds of photos in their lawsuit, that it is more impressive to the court. I think after a certain point, it actually starts to get to the court saying, yes, we get it. We understand. You can use one example image and not 15, but this is an overkill kind of lawsuit trying to explain exactly how important this is to them just with volume alone. Midjourney also copies and uses plaintiffs' copyrighted characters to market and promote its image service, encouraging even more infringement and falsely implying plaintiffs' endorsement. And the endorsement question is a separate one. It's really more trademark-oriented than copyright. Trademarks are designed around letting you know who is selling something and who to affiliate that something with, so that if you see Darth Vader in a compromising position, you can say Disney must have authorized that, and so I can think negatively about Disney now. But that's not exactly what's happening here, and yet they're concerned about it because Darth Vader, and I would be willing to bet certain of their other important characters are probably trademarked images of the Disney Corporation. Midjourney controls what copyrighted content it selects, copies, and includes in its image service, and it has the means to implement protection measures to prevent the ongoing copying, public display, and distribution of plaintiffs' works. Now, that protection measures concept is, I think, where Midjourney is going to get into the most trouble, right? We heard in the Anthropic lawsuit that the court was buoyed in part by the notion that when Claude puts in its LLM filters, it's preventing users from getting fully copyrighted infringing material back out from that system. To the extent Midjourney isn't doing that, that's a problem for them in this particular lawsuit. And as we will see, the fact that they are doing it for other things is extraordinarily suggestive of the fact that they could have done it for these things and are essentially taking a deliberate step to allow copyright infringement through their service, which is a little bit different than the overall tool argument we just talked about in paints and canvases. And so I do think Midjourney is likely to find itself in more trouble than the Anthropics of the world insofar as the fact pattern of that authorship case that we read to begin with. We see other pictures that Midjourney outputs that are clearly based on Disney and DreamWorks and Universal characters. This case is not a close call under well-settled copyright law. Again, they want to get to the point where they can inflict maximum damage on Midjourney. So they are trying to establish from a legal perspective that the infringement was willful. I do not agree with this paragraph, but this is essentially advocacy on behalf of the client. Midjourney set up a lucrative commercial service by making countless unauthorized copies of plaintiffs' copyrighted works. That's the training process. And now sells subscriptions to consumers so that they can view and download copies and derivatives of plaintiffs' valuable copyrighted characters. This is textbook copyright infringement. And again, that's very summary. That's, of course, what you want to put forth if you're representing Universal and Disney. I do think it's a close call. I do not think this paragraph is accurate. The reason it exists here is because it's important for them to assert that it isn't, so that they can assert that the infringement is deliberate and willful. That's how they get the big bucks in terms of the damages. That's how they get a better judicial judgment for their side of the case. All right, we got some scrolling to do. We know who the parties are. We're going to assume the venue is fine. The factual background is, hey, we make movies. Our movies are pretty popular. I got some pretty popular characters. Yep, we get it, guys. I'm not sure you needed 17 pages to get to this point, but hey, you do you. You got a lot of money. You can pay those lawyers. Unbeknownst to plaintiffs, Midjourney first launched its image service in February 2022 as a bot accessible within the Discord communication platform. I just highlighted this because I thought it was an interesting piece of history. I didn't realize that Midjourney was first a Discord bot. Maybe you all did at some point, but I do think it's interesting that the big things in life can often start small, which is what I like to remind myself of when I'm trying new things. Midjourney consistently and accurately reproduces, publicly displays, and distributes copies and derivatives of characters from Disney's Star Wars franchise to its subscribers. In response to the simple request, often referred to as a prompt, asking to see Yoda with a lightsaber in IMAX, Midjourney accessed the data about Disney's copyrighted works that it has stored in its image service and then reproduced, publicly displayed, and made available for download further copies of Disney's Yoda, as shown in this screenshot. And again, it's pretty close. It's certainly an AI Yoda as opposed to a screenshot Yoda here. But importantly, again, as part of this conversation is the user is asking for Yoda with a lightsaber. And if the Anthropic case holds with respect to training LLMs, then a lot of this falls by the wayside because the fact that things were copied inside the LLM to get you to this point in output is not in and of itself a legal problem. That if LLMs are transformative enough to essentially get automatic fair use treatment for their training, then we can only really talk about the output, not the rest of this stuff about reproduction, public display, and everything else. So the output is the stronger argument because we haven't actually seen it decided by any court. And again, we're going to scroll through a lot of pages of pictures. I think we can grant to Disney and Universal that Midjourney, when prompted, 100% outputs Bart Simpson, Darth Vader, and any other character that you could want from the Disney Universal menu of character selections. And certainly it's understandable why Disney and Universal have a problem with that. I can see why that would be an issue for them, but it doesn't necessarily mean that it's not fair use for purposes of the LLM, or at least that it's not blocked by the fact that the tool set itself isn't doing this as much as the prompters are doing it, which is going to be an argument they're going to have to deal with. We'll see how they do towards the end of this document. We're only on page 48 of 143. So lock in, everybody. I'll get there, I promise. Lots of pictures. We're willing to grant this, Disney and Universal. We're willing to grant it. The fact that Midjourney generates copies and derivatives of plaintiffs' copyrighted works demonstrates that Midjourney, without plaintiffs' knowledge or permission, copied plaintiffs' copyrighted works to train and develop its image service. And again, that's on the assumption that that's illegal, right? They include that sentence on the notion that it is an infringing act to train the LLMs using movies and cartoons and whatever else these companies have. It may or may not be. We don't know. And since we don't know that, we've got a real problem with willful infringement on this whole thing. It also shows that Midjourney's AI image service, through software programming and computer storage devices, embodies copies of those works, right? The fact that you can pull up what a Darth Vader even is means that you had to keep some kind of memory internal to you that you know what Darth Vader looks like. So that has to be a copy within the concept of what an LLM is. The law doesn't know what an LLM is. When we draft the Copyright Act, nobody has any notion of what an LLM might even be. So is that a copy if it's bits and bytes that are otherwise kind of concepts within an LLM software framework? The law definitely doesn't know. And again, we get into whether or not that's willful infringement if the LLM, as this combined data set, is in fact embodying copies of these works, as Disney and Universal put it. You can see technologically how the law is going to throw up on this, right? We have no idea whether or not this is accurate. We can certainly understand with your output presentations why this bothers you and why it looks a lot like a human being in a sweatshop somewhere making trapper keeper derivative screenshots, but that's not necessarily what's happening here for purposes of the law. Mr. Holtz confirmed that Midjourney never sought any copyright content holders' consent to copy and exploit their works, meaning to train their LLMs. In other words, Midjourney used software servers and other technology to store and fix data associated with plaintiffs' copyrighted works in such a manner that those works are thereby embodied in the model, from which Midjourney is then able to generate, reproduce, publicly display, and distribute unlimited copies of plaintiffs' works as defined by the Copyright Act. This is a novel question. We've already talked about that. Here, Disney and Universal is trying, with all of the strength of their legal words, to say this isn't novel. This is just somebody copying our stuff. And just ignore all of the middle steps and all of the newness of what an LLM is or how a prompter interacts with it to get to the point that says, look, this is clearly copying our stuff. Disregard everything else and just look at it from that perspective at 30,000 feet. I think the court's unlikely to do that, as we saw in the Anthropic case, but they do have a good case for Midjourney could be doing more here to protect things, as we will see. As shown in the images from their article displayed on the next page, Midjourney version 6.0 generated images that were copies of stills from Disney's movie Avengers Infinity War. And you see that they are, in fact, very close to stills. You can see what the AI did in terms of changing things up a little bit, but gun to my head, if you were to show me the stuff that is from Midjourney, I would have told you that that's a screenshot from an Infinity War. I have not memorized every screenshot in that movie. So, yes, that would suffice for that purpose. And we see that the prompt, at least as described by them, is just show me a movie screen cap from the Avengers Infinity War from 2018, halfway through the movie. And they're using this as proof, essentially, that the LLM is trained on this content. And I think I'm using LLM incorrectly. Midjourney is an image generator, but the service in and of itself is trained on these kinds of things. They also note, and I think this is more impressive for their argument, that you don't actually have to ask specifically for minions or anything else to have these prompts popped this way. Yellow 3D cartoon character with goggles and overalls makes a minion. So this proves not only that the minions are stored in some respect inside the model, but also that a prompter doesn't have to be trying to infringe to wind up with an infringing outcome, which means that Midjourney is taking a more active step in the infringement itself, right? If the prompter has to ask for infringement, then it's very difficult to say that the tool creator is themselves infringing. Not impossible. In fact, part of this, I think, is going to be a strong argument for Disney and Universal. But the fact that it's outputting things that are infringing without the request to infringe is a good argument for them. Notably, they say it did not expressly request Simpsons characters for these outputs, that instead said popular 90s animated cartoon with yellow skin. Obviously, they're trying to elicit certain responses like this for purposes of their legal case. And you can say the same about the prompter that's asking for an animated cartoon with yellow skin. But still, them not asking for Bart Simpson, them not asking for the Simpsons specifically, does lean towards Midjourney as contributing to the infringement at bare minimum. Dr. Marcus and Mr. Southern's detailed numerous prompts in response to which Midjourney generated outputs featuring Disney's and Universal's copyrighted works, even when the prompt did not expressly request copyrighted works. And that's the point that they're making, the one that we just talked about. This is Black Armor with Light Sword. In response to Dr. Marcus and Mr. Southern's single word prompt screen cap, Midjourney accessed the data about Disney's copyrighted works that it is stored by the image service, and then generated the following output that copies Disney's Spider-Man and Loki characters from its Marvel franchises and Elsa from Frozen. Yep, those sure do look like screen caps from a Disney movie. They do. In response to Dr. Marcus and Mr. Southern's popular movie screen cap, Midjourney accessed the data about Disney's copyrighted works. Again, here's Iron Man. Here's Toy Story. Here's some Star Wars stuff. This is Protocol Droid from classic sci-fi movie. It pops up with some Star Wars looking things. Not entirely Star Wars-y, but maybe enough to qualify as derivative works. Here's Luke Skywalker, looking a little thinner in the AI's interpretation of him. Midjourney publicly displays copies of plaintiff's characters on their Explore page. So here we have, again, separate from the prompts, Midjourney has some pages that essentially say what other people have made. And these Explore pages are themselves infringing, claims Disney and Universal. I think they actually probably have a pretty good point here. This is for Iron Man. This is for Deadpool, Spider-Man, etc., etc., etc. Like I said, one thing that they do in this lawsuit is hit you with 24 examples when maybe 5 or less would do. This is where a court gets tired. By maintaining and publicly displaying infringing copies of plaintiff's copyrighted works on its Explore page, Midjourney is advertising its ability to reliably reproduce plaintiff's copyrighted works for its subscribers. Midjourney's Explore page manifests its express intention and desire to attract Midjourney subscribers by exploiting the availability of infringing plaintiff's content and its ability to reliably reproduce plaintiff's copyrighted works for its subscribers. Hey, we're not just infringing, we're going to advertise how good we are at infringing. Several websites, Reddit threads, and online posts confirm that Midjourney subscribers are drawn to Midjourney due to its ability to infringe on plaintiff's copyright works. So, unlike most lawsuits, we're not going to go on to a Reddit, subreddit, stream of consciousness description of bringing up quotes that say, hey, look what I can infringe, essentially. And they find this to be useful. I'm not sure this is useful for the legal question other than to try to highlight that Midjourney knows what it's doing. But again, if Midjourney doesn't know that what it did is itself infringing, I don't think you can get to willful infringement on a legal basis. Disney and Universal want to get there because that's where the big money damages live. Midjourney chooses to not take any reasonable measures to prevent further copyright infringement. This is a very strong argument in my opinion. Midjourney could stop, or at least minimize, its ongoing copyright infringement. Specifically, in addition to discontinuing its large-scale infringement of the copyrighted works to train its models, Midjourney could readily implement copyright protection measures to prevent or limit infringing outputs. Again, we already talked about in the Anthropic case, the training side of things may already be a lost cause, especially if a number of courts take up most of, if not all of, the reasoning of that San Francisco District Court. But in terms of output, Midjourney not taking any protective steps for that output is probably something that Disney and Universal could win even on the Anthropic decision kind of model, because that decision points out that there is non-infringement on the output side for Claude. For example, if a Midjourney subscriber submits a prompt asking for images with violence or nudity, Midjourney's protection measures cause a response that says, sorry, the AI moderator is unsure about this prompt. It might not meet our community guidelines, or our AI moderation might have gotten confused. Please try a different one. The error messages explain Midjourney's community standards, which list 4 categories of prompts that Midjourney does not allow. 1. Content that disrespects, harms, or misleads about public figures or events. 2. Hate speech, explicit or real-world violence. 3. Nudity or overtly sexualized images. And 4. Imagery that might be considered culturally insensitive. Midjourney's terms of service further describe its prohibitions on adult content, gore, and images for political campaigns, and ask subscribers to avoid making visually shocking or disturbing content. The terms of service then explain that Midjourney will block some text inputs automatically. Now, to Disney and Universal's point, this is ordinarily a list where we would see you won't make anything that you don't have the rights to. You won't make anything that infringes on the rights of others. That's something we saw with respect to the Steam terms when discussing some of the payment processor stuff in virtual legality. We've seen it in other contexts, in other contracts and licenses that we've looked at in the past. So it is unusual that Midjourney does not include as one of its not allowable categories things that infringe on the rights of others. So the implication is the lawyers know how to write this stuff. This is kind of a standard bit of language with the copyright infringement concept removed. It is indicative of a company that is deliberately trying to encourage copyright infringement. And the fact that they do block certain things means that they could have blocked things that were infringing. This demonstrates, as Disney and Universal say, that Midjourney controls and has the ability to control generative outputs through readily available technical protection measures. In contrast, other AI services have demonstrated that reasonable, readily available copyright protection measures can prevent or at least limit infringing generative AI outputs, including by screening image outputs for infringing material before the image is displayed to the subscriber and by refusing to allow generations based on prompts likely to elicit infringing content. Now look, I'm a guy that wants to see these tools do as much as they can, but I also want to see them do as much as they can while still allowing for copyright and intellectual property rules to encourage capital and media companies to make things for us to actually use in our own imaginations and in the world around us. I love pop culture. I love movies and video games. We've talked about that a lot on this channel. So I want the AI to be able to do all the things that it can, but I also want everybody to be acting within the auspices of the law as much as they are able. So in other words, I want them to find a model that allows them to license the things they need to license to operate for Disney and Universal and everybody else to be happy with that model and to move forward from there. I don't love it when a generative AI says, I can't talk to you about that prompt, whether it's Midjourney or anybody else. But reasonable compliance with legal parameters would require some of these protections to be in place. The fact that Midjourney halfway does it does it for certain things and not for others, does in fact imply from a legal perspective that they could have prevented copyright infringement if they were inclined to, that they are deliberately not doing that. And that probably does, from a notion of fairness and equity in the court, suggest that Midjourney is more liable or should be more liable on this particular ground than maybe other AI companies would be in a similar position. Based on the facts alleged in this complaint, plaintiffs are informed and believe that Midjourney's forthcoming video service will allow paying subscribers to request copies of videos featuring plaintiffs' copyrighted characters and incorporating plaintiffs' copyrighted works, and will reproduce, publicly perform, and distribute videos containing and infringing plaintiffs' characters. Again, at the heart of this is Midjourney's going to make videos. That's at the heart of why this lawsuit happens right now. It's that these companies are deathly afraid of the video generation that is on the horizon. I don't know how far that horizon is. We heard in the Hollywood Reporter article that the Showrunner project thinks it can launch in 2026. I don't know whether they can or not. The tech companies, the AI companies, tend to be very aggressive in their road mapping of these things. Sometimes, though, they're even happening faster than they project. So we'll see. CD Craft Gaming says it's impossible for our business model to not break the law isn't a valid legal defense. That is 100% true. That is accurate. You're not going to win a legal case by just saying, hey, our thing couldn't exist if we didn't break the law. The court would rightly say, well, that's up to Congress to determine. So go petition to them. But that's not exactly what they're saying here. They're saying that the way we are training our data sets doesn't break the law. And we'll see an answer eventually from Midjourney on this point. They might be one of those actors that is across the line that the courts and the legal system try to bring back. But the entirety of the AI industry is not, on its face, willfully infringing just based on the fact that they ate all this data to build their models. James Randolph says, I wonder if we eventually end up with a safe harbor law. I'd have to look at what that would mean in this context. Like if you built your stuff early enough, we're not going to hold you liable for what might otherwise be infringement, but we're not going to allow it after a certain point. That if you demonstrate that you have certain protections in place on your output, that we're not going to look too deeply into your input. There's a number of ways that this could look, right? Congress hasn't updated the Copyright Act or the intellectual property laws in eons and are unlikely to do so in the near term. But this is going to become a more pressing issue as we move forward. Witness Multichick says they will need a good data expert, in my opinion. Are you offering? They're probably going to need a lot of tech people to help them understand any of this. Congress needs them. Supreme Court needs them. These companies, frankly, need to understand the legal landscape maybe a little better than they do. Although it's hard for me to say that necessarily because I've certainly had a lot of clients in my history where they can get good legal advice and say, no, we're willing to take on that risk. We're just going to break things. And sometimes the business people just decide that. They can get all the good legal advice in the world, but I can't decide for them what they're going to do with it. All right, back to the case. As Disney and Universal allege, Midjourney illegally and unfairly competes with companies that license plaintiffs' copyrighted works for the purpose of creating authorized derivatives and undercut those existing and potential licensing markets. So here they're skipping ahead past the fair use argument to say, look, however you might think about this thing, we actually do have a market for selling pictures of Elsa on Trapper Keepers or file folders or making metal artwork that you put on your wall. And to the extent that you are infringing on our rights in that area, you are limiting our ability to sell those licenses. So that does affect us. So court, think about that as you're analyzing these things. Midjourney is also contributing to consumer confusion regarding what is lawful and what is not lawful by misleading its subscribers to believe that Midjourney's massive copying and countless infringing images are somehow authorized by plaintiffs. So this actually isn't a legal charge as much as it's just a, hey, court, remember, these guys are bad guys, right? One of the reasons we put 100 pages of material in this lawsuit is to remind you that not only are they bad guys, they are voluminous bad guys, and they're contributing to consumer confusion about what is legal, right? And that's probably true, although I would argue that Disney, by not otherwise policing copyrights on places like Etsy and in other contexts, are contributing as much or more to misunderstandings about what is allowed and not allowed from people out there. That's not really their duty, It is not the duty of Disney. It's not the duty of Midjourney to make sure that you understand what's legal and illegal. It's really not. And so this is just out there to try to say Midjourney is a bad actor. It's not otherwise a part of their legal claim. And that's fine. This is a complaint document. You can make all the rhetorical arguments that you want. But I do note that while, as a lawyer, I am sensitive to people being misunderstanding of what's legal and illegal. That's why virtual legality exists, is that I was out there seeing articles kind of wrongly describe the legal landscape of things in video games and pop culture. Hopefully this is illuminating for people that want to have these conversations here on this channel. So I am very sympathetic to this being an argument against the Midjourneys of the world. I do not find it to be legally actionable or useful for understanding whether or not they should be liable under statute. Then they ask for some relief. First, direct infringement. Midjourney's acts of infringement are willful. And again, they say that there's infringement on the training and the outputs. So that's essentially two different avenues that they're trying to argue. The training has the issue of a court in the United States already finding that training is transformative and fair use. We'll see if another court takes that up or doesn't. And then the outputs is their stronger argument because there is clear derivative action in the outputs that they're going to be able to show with all that imagery that we saw in the first 100 pages of this lawsuit. Their biggest problem there is that intervening prompter concept, right? So Midjourney may be a good defendant for them for this case because they don't have those protections in place. But the prompter in most instances is going to provide a certain amount of cover for the tool creator, the LLM, the generative AI model, because the tools in and of themselves are not, in general, generalizing here, in the United States, the ones that are responsible for the infringement, right? One of the things that I did talk about pretty early on in virtual legality a lot was like, how does Little Big Planet or other games that allow content creators to create whatever they want, maybe Roblox is a better example now in 2025, how do they get away with all of the infringement that happens in their libraries? And the answer is they put in their terms of service, don't infringe. And if we find out about infringement, if we're notified of infringement, we'll take it down. But otherwise, the tool maker in the United States and other jurisdictions is not responsible for what the tool user does with the tools, for the most part. And that's why we get the second claim for relief. Secondary copyright infringement. Plaintiffs allege that Midjourney is the direct copyright infringer of the copyrighted works at issue in this litigation. So to be clear, court, we think that they're directly infringing. But if for some reason you go crazy and decide against that, however, in the event that Midjourney argues that it is not the direct infringer of plaintiff's copyrighted works and its own subscribers are somehow, completely crazy argument, the direct infringers of the copyrighted works, then plaintiffs plead in the alternative that Midjourney is nevertheless liable for secondary copyright infringement. Okay, so we are smart lawyers. We presuppose that Midjourney is going to say, hey, look, we don't make the prompts. The prompters make the prompts. Half of the stuff in this lawsuit is you prompting for infringement. That's not on us. Even if that's the case, even if the prompters are the infringers, we say Midjourney, the tool maker, is secondarily liable. What does that mean under the law? It means that they allowed/encouraged people to infringe with the tools that they made. If Midjourney contends that its own subscribers are the volitional actors responsible for making the copies of plaintiff's copyrighted works identified in this complaint, such copying was done and is being done without plaintiff's authorization or consent and constitutes copyright infringement under the Copyright Act. If they contend that it's the users, we still say that the users are violative. Midjourney is then vicariously liable for these acts of direct copyright infringement. In other words, they're liable for the acts of their users, assuming they are adjudicated to be direct infringement by Midjourney subscribers. Midjourney has the right and ability to supervise and or control the acts of direct copyright infringement. Midjourney has protection measures already in place that expressly block the generation of certain content, disrespect of public figures, hate speech, violence, nudity, culturally insensitive information. Midjourney, however, has not implemented those measures to limit its image service from infringing plaintiffs' copyrighted works. Now, interestingly here from a legal perspective is the notion that this is a strong argument. They are blocking certain stuff and they're not protecting us. That one of the things that you could say if you were in the room with Midjourney and their board is that you don't want to take half measures, right? You don't want to do this. This is a good argument against us, that we prevent disrespectful images of public figures, we prevent violence and nudity, but we don't prevent infringement. We should not be going out there with the technological capability of stopping anything. That one of the things that you see pretty often in cases like this or in statutes that do something like this is that the right answer from a corporate perspective is to say, well, okay, we're not going to take half measures. you can all agree that this is good that we're preventing these things, but we're not going to prevent them anymore because it exposes us to the things that we aren't preventing. It gives us liability. It makes us a moderator kind of figure in the platform and tool set that we're trying to provide. We don't want any of that. And so we're not going to take on even half of it. That's why you see certain statutes like the infamous Communications Decency Act, CDA, Section 230, that says just taking steps like this do not make us liable for the things that we don't do, because otherwise we can drag in all this vicarious liability for all these bad things. You might need to see something like a CDA 230 for generative AI models. Congress would have to look at that as a separate question. These are the kinds of things that might come up on a statutory level because the law as is written today doesn't handle these things very well. And if I'm Midjourney, I look at an argument like this, I listen to Hoeg saying that this is a strong argument, or whoever my lawyer is that actually works for me, and say, all right, well then maybe the best thing to do is to allow violence and nudity and culturally insensitive information on our site. Turn off all the bots. We can't do it. We found it to be unviable. And if you see that kind of action from other LLMs, this paragraph and this argument is the reason why you might see a general kind of loosening of restrictions if they can't restrict every possible thing. So it's interesting to read things that way. This is the problem with being in my mind all the time, is you can see all the various second and third order functions of these things. But I do think that Disney and Universal have a strong argument that the fact that Midjourney can get its prompts to block this stuff means that they are deliberately not blocking copyright infringement. And that means that they probably should be held vicariously liable for the infringement that occurs. At all relevant times, Midjourney has derived a direct financial benefit from each act of direct infringement at issue. So one of the areas in which it's difficult to kind of ascribe damages and complaints to another party that's not the direct infringer, right? In this alternative argument that Disney and Universal is putting forth, the court has found that the infringers are the prompters, the users. And so they have to say Midjourney should still be liable for that. They have to say, well, okay, so they could have protected it. Also, they're making money off of this infringement. At all relevant times, they derive that direct financial benefit from the subscriptions they sold. They're also secondarily liable as a contributory infringer because they knowingly and materially contribute to, encourage, and induce the infringement through the Explore page and others. Midjourney had specific knowledge of and is willfully blind to the direct infringement of plaintiff's copyrighted works done through its image service. At a minimum, through their cease and desist letters, plaintiff put Midjourney on notice that its image service was being used to infringe plaintiff's copyrighted works and the specific characters identified in the letter. So they sent a letter and they say, hey, look, there's all these infringements on the Explore page and otherwise, take them down. Midjourney says no. And now Disney and Universal want to say, okay, the fact that they knew this infringement existed means that now they're willful, contributing to the infringement that's happening on their site. They're making money off of it. You should hold them liable for that action. I think Disney and Universal are probably right here. But I would note that as a piece of evidence, just the sending of the letter does not mean that Midjourney has knowledge of infringement. In particular, Midjourney or another company that got a similar letter could look at whatever was presented in that letter and say, I see how you're upset, but I don't personally think that's infringement. I don't think it's legal infringement, and so we're not going to take it down. That disagreement doesn't mean that they now have complete knowledge of that infringement. The court would have to determine the infringement existed and then essentially rule against them and say it was obvious that this infringement existed and you deliberately kept things up. So that rises to something like willful on the level of output. Willful is not going to attach to the training side of things. That's just way too gray for the entire legal system right now. But on the output side, that's why this argument is so much stronger. And they asked for damages and for them to stop. So that's a court case. You made it through, I think, 200 pages of legal cases with me today. That's pretty normal for Hangouts and Headlines, right, folks? Told you this was going to be a meaty one. What else we got here? Massive damages are in play. As I said, probably not, because it's not clear that any of this infringement is willful. I think that's all the Hollywood Reporter wound up writing on this. So the big note from a Hangouts and Headlines perspective on this is this notion that you can see they adopt the Universal Pictures kind of perspective that all uses of this stuff is stealing, piracy, other language that you see in the article. You want to note those kinds of uses of language when you're reading through these things. And if you do, you will see that a lot of articles on things that are more important even than whether How to Train Your Dragon is protected by copyright law or artificial intelligence or otherwise, that others are using language like this to condition how you read the article before you get to the substance all over the place. So keep that in mind when you're reading. Stay safe out there. And thank you for letting me talk with you all about AI for, I think, an hour or more at this point. So Almost 2 hours. Look at me go. What a show. If you guys like this content, if you like these discussions, again, please consider supporting us on our Patreon through memberships, gifted memberships, or super chats. I appreciate everybody that's already done so far. Otherwise, just subscribing, telling your friends that we're having these conversations is super useful to the channel. And commenting helps so much with respect to what YouTube actually likes and puts out there for the world at this point in time. So, with that all said, what are your questions and comments? Let's talk to you all about anything that you have on this. I'm sure you have no thoughts on artificial intelligence whatsoever in the chat. You never do. But I appreciate you all being with me here for 2 hours now. These are videos that I'm very excited about. Like I said, I had prepped an AI video early on, so I had already thought about a number of these things to talk with you all about. This just seemed like a good entry point for it. I hope you don't mind me kind of co-opting the Hangouts and Headlines format for a bit of a virtual legality in there. But please do let me know, either with super chats, a Q:, or an @Hoeg Law, that you have a question for me to answer and comments that I can give. I would love to help you out with anything before I go today. Let me know, and I will take a sip of my tea. Should I just says that was awesome. Thank you for covering this stuff. I love covering this stuff. This is, in my opinion, technologically speaking, the most important concept and question that people have to grapple with in 2025. What does AI mean? How does it work in practice? How do I feel about it? And how should it work from a legal perspective from my profession? Witness Multi-Chick says, I appreciate your perspective, Rick, as a data engineer. I always see that as a praying emoji. I think it's a high five emoji in this context. Blue heart emoji, thumbs up emoji, scales of justice emoji. Thank you. Thank you, Witness Multi-Chick. Thank you for being here and for your insights on data collection and data analysis. Already hit the like, just listening while I work, says Edward. Yeah, do hit the like button or the dislike button. Really, any button you hit on YouTube, YouTube is going to know it as you being a person and not a robot watching. So that definitely helps move the videos out into the world. I have not had the cadence that I had certainly in 2022 or before in the most recent time on this channel, but we've gotten to a pretty good record now in week 4 or so of this June. But that actually raises an important point for me to tell you all. Before you all go, I do have to mention that this is going to be a brief hiatus from the channel. I am finally going on a vacation for the first time in a year next week. So there will not be a virtual legality or a Hangouts and Headlines next week. You won't see me on Last Stand Media. You won't see me on the Bitcast. I think the Bitcast is itself taking a couple weeks off. So I desperately need it. I really do. I'm going to go and stare at a lake a little bit for a week. And I will miss you all while I do so. I will be back after that in the week of the 17th, I believe. But thank you so much for being here. And thank you so much for supporting me and the channel and my recovery. I couldn't do it without you. And I really appreciate everybody. I already knew that people were going to say vacation time. Yeah, it's I got to get out of here. It's going to be great. I need a little calmness. And Sibling Creature, enjoy your vacation, Rick. Thank you so much, everybody. I'm looking forward to it. Back to the questions and comments slide. I can hit the buttons. I can cover up my face with comments. It's all good. Jedi Jess says, as someone who has followed you since step, it's great to see you bounce back, Blue Heart. I'm getting there. I like this cadence right now. It doesn't kill me quite as much as it did very recently. So we're going to try to keep this up as much as I can. And certainly when I see articles like this one on Universal and their disclaimers and what they want to do with respect to AI, I thought it was a good entry point to talk to you all about the AI I wanted to talk to you about 2 months ago when I just didn't have it, honestly. So I appreciate you all and all your well wishes. Everybody's just saying thank you and have a good vacation. Thank you guys for being here. I really appreciate it. If you haven't seen the most recent 2 virtual legality episodes that are about freedom of expression and the payment processors trying to tamp down on content on video game platforms like Steam and itch.io are very, very popular. YouTube seems to love them. I apologize in advance for the level of advertisements that appear to be running on those videos. People have commented on those a little bit. That is a good indication that YouTube likes the content. So I am apologetic for too many commercials, but it is a good sign that the channel is back on the upswing, and YouTube has once again deemed us to be worthwhile content for its algorithmic graces. So I really appreciate you all doing that, leaving comments, helping me out with the channel entirely. I'm going to see you on the next one. It's just not going to be next week. Thank you so much for being here, everybody. I will catch you then.
Virtual Legality is a YouTube video series with audio podcast versions presented as commentary and for education and entertainment purposes only. It does not constitute legal advice and does not create an attorney-client relationship. If you have legal questions about the topics discussed, please consult your own legal counsel.